Thank you, sir. Thank you, ma'am. I would now like to request our Honorable Vice Chancellor, sir, Professor Dr. Jayanand, to welcome the resource person, Professor Dr. Vinny Kapoor Mehra, ma'am, by presenting a shawl and a sapling. Thank you, sir. Thank you, ma'am. I would now like to request Mr. Pramod Kumar Goyal, sir, Director, SLCS, to give a brief introduction of today's resource person and guest speaker, Professor Dr. Vinny Kapoor Mehra, ma'am. Please, sir.
Good afternoon. Honorable Resource Person, Professor Dr. Vinny Kapoor Mehra ji, Honorable the Vice Chancellor, Dean, Institute of Engineering and Technology, Dr. V.K. Tyagi, Directors of different schools, dear students, ladies and gentlemen. We are honored to introduce our esteemed guest, an expert in the field of constitutional law, who will shed light on the Uniform Civil Code from a constitutional perspective. With a wealth of knowledge and experience, our guest will guide us through the intricacies of this complex and important leg of topic, providing valuable insights and analysis that will undoubtedly enhance our understanding of UCC and its implications. Professor Dr. Vinny Kapoor Mehra is a distinguished academic and legal professional who has held significant roles in various institutions and government committees throughout her career. She served as the former Vice Chancellor of Dr. B.R. Ambedkar National Law University, Sonipat. In addition, she held the position of Commissioner at the State Information Commission in Punjab from 2016 to 2019. Before this, Dr. Kapoor served as the head of the Department of Law at Guru Nanak Dev University in Amritsar during 2015-16. She also played a crucial role as a member of the syndicate at Guru Nanak Dev University in Amritsar in 2013-14 and served as a senator at the same university for 2 terms spanning 2008 to 10 and 10 to 12. Her contributions extended to a national level as well. With notable appointments by the Government of India, Dr. Kapoor was a member of the National and Executive Committees responsible for celebrating the 350th birth anniversary of Guru Gobind Singh Ji in 2016-17. She also served as a member of the Constitutional Review Committee in 2012 and was part of the core committee of the National Human Rights Commission from 2020 onwards. Dr. Kapoor is a life member of the Indian Law Institute in New Delhi and actively participated in shaping her education in Punjab. She was a member of the committee responsible for drafting the Higher Education Council Act from 2015 to 2016 and contributed to the committee for celebrating 150th birth anniversary of Swami Vivekanand from 2012 to 2014. Furthermore, she dedicated her expertise to the Juvenile Justice Board under the Ministry of Child and Women Welfare Empowerment. Her academic achievements are equally impressive. Having received a postdoctoral fellowship from the University Grant Commission from 2009 to 11 and a scholarship from the International Institute of Human Rights in 2012. Dr. Kapoor received the India's Icon 2021 award from the National Human Rights Commission in Delhi and the Global Excellence Award for being recognized as an outstanding academic leader by the Global Chamber of Consumer Rights in 2021. In the realm of research and education, Dr. Kapoor has made significant contributions, including the publications of 2 books and 50 research articles. She has supervised 6 PhD students, and 1 postdoctoral scholar, guiding 10 to the successful completion of their degrees. Additionally, she has mentored 150 LLM dissertations and project works. Dr. Vinay Kapoor Mehra is widely recognized as an expert and has lent her expertise to institutions like the UPSC, Union Public Service Commission, UGC, NEC, and several universities and institutions in higher learning. She has been a prominent keynote speaker, resource person, chairperson, chief guest, and guest of honor at numerous international and national seminars, symposia, and conferences. Furthermore, Dr. Vinay serves on the panel of National Assessment and Accreditation Council, that is NAC, for the assessment and accreditation of higher educational institutions, emphasizing her commitment to maintaining and enhancing educational quality. Notably, she cracked Haryana Judicial Service in the year 1986 on her first attempt and chose to pursue academia over the judicial career. Thank you, ma'am. We are really honored to have you here.
Thank you, sir. Now, I would like to request our Honorable Vice Chancellor, Sir, Professor Dr. Jayanand, to kindly share his words of wisdom. Please, sir.
Good afternoon. Today's luminary speaker, Professor Vinay Kapoor Mehra, Director of School of Law and Legal Studies, Professor Pramod Goyalji, faculty members, other deans, and most importantly, my students. Today, you are going to get the illumination of such an excellent academician, Professor Vinay Kapoor Mehra. She has been in the academics by her own choice. I have heard that she has been selected for the judiciary, but she left the opportunity and she joined the academics. So such kind of personality, it is very rare chance to meet. So I would request you all to stand up and welcome her. Thank you, ma'am. Thank you. Thanks for coming. Please be seated. Really, it's a rare chance, and I will not take much time because she is the giant academician with the professionalism of law. So I will not cut short your exposure. I will request Honorable Ma'am to continue her delivering whatever the experience, whatever, because she knows what is the importance of experiential learning, which is now these days we all are working for the NEP. So thank you, ma'am. Thanks for joining us. Thank you.
Thank you, sir. I would now like to call Zorisha ma'am, student of BLLB second year, to please come upon the stage and introduce the topic for today's expert lecture. Uniform Civil Code, a constitutional perspective.
A very good afternoon to everyone present here. I'm thankful for this wonderful opportunity of being here and introducing the today's topic of today's expert enlightenment. Uniform Civil Code resonates with one country, one rule to be applied to all religious communities. The code means that all sections of the society, irrespective of their religion, shall be treated accordingly to a national civil code, which shall be applicable to all uniformly. It covers areas like marriage, divorce, maintenance, inheritance, adoption, and succession of property. It is based on the premise that there is no connection between religion and law in modern civilization. If we look into the historical perspective, during the colonial era, the Lex Loci report of October 1840 stressed upon the importance and necessity of uniformity in the codification of Indian law. But it also recommended that personal laws of Hindus and Muslims should be kept outside such codification. Moreover, the Queen's 1849 proclamation promised absolute no-interference in religious matters. So, while criminal laws were codified and become common for the whole country, personal laws continue to be governed by separate codes for different communities. During the post-colonial era, prominent leaders like Jawaharlal Nehru, Dr. B.R. Ambedkar pushed for a uniform code. However, they included the UCC in the directive principles of state policy, mainly due to lack of consensus among all stakeholders and lack of awareness among the masses during the time. Therefore, it was considered safe to place the subject dealing with uniform civil code in the chapter dealing with directive principles of state policy. Hence, Article 44 have been crafted with a directive that states shall endeavor to secure for the citizens a uniform civil code throughout the territory of India. It appears that there is no sincere effort from the political leadership to translate this constitution mandate into reality. This inaction was subject to criticism by Honorable Supreme Court of India in popularly known as Shah Bano's case, where Honorable Court was constrained to observe that the spirit of the Constitution has not been put into action. If permitted, I would like to say that this matter was considered by the Law Commission of India in the year 2018. Under the chairmanship of Honorable Dr. Justice B.S. Chauhan, and the Law Commission had to observe that the country is not still mature to adopt a uniform civil code. India has a unique blend of codified personal laws of Hindus, Muslims, Christians, Parsis. There exists no uniform family-related law in a single statute book for all Indians, which is acceptable to all religious communities who coexist in India. However, a majority of them believe that UCC is definitely desirable and would go a long way in strengthening and consolidating the Indian nationalhood. The question is not of minority protection or even of national unity. It is simply one of treating each human with dignity, something which personal laws have so far failed to do. Thank you.
Thank you, Zorisha ma'am. I would now like to invite our keynote guest speaker of the day, Professor Dr. Vinny Kapoor Mehra ma'am, to enlighten us with her thoughts on the topic Uniform Civil Code, a constitutional perspective. Please, ma'am. Please give a big round of applause for ma'am.
Thank you so much. Honorable Vice Chancellor of this university, deans, directors, faculty members, and dear students. So we are to discuss today Uniform Civil Code. How many of you have already read about it? So very few. I've been working on this topic since 1992. While I was doing my PhD. So it's related with the Uniform Civil Code, in fact. So do we need Uniform Civil Code? I just want to ask you. Only two says yes. So majority says no?
Yes.
Or you don't know the relevance of Uniform Civil Code. That's why you are quiet. Yeah. So in fact, Uniform Civil Code means code is where you have consolidated all the laws. So civil, we have already CPC, CRPC and IPC. These are the codes where you have consolidated various aspects of a particular laws. So I say that Uniform Civil Code is misnomer. Do you agree? Who says yes? Who says yes? Because already we have so many civil laws where we are having uniformity. It's only the area related to the family matters. Understand? It's only issues pertaining to family law that we are not uniform. So instead of saying Uniform Civil Code, we should call it Uniform Family Code. That will be a better nomenclature. That's why I say Uniform Civil Code is a misnomer. Now, as already introduced by Alicia, Jolisha, that this is the only country in the whole world. India is the only country where different religious communities have their family laws. Hindus have their own, Christian own, Parsi, Jew, and Muslim. No other country in the world has such provision. So we are very liberal, no doubt. So we give space to everyone. So that's why anybody who is turned out of his country, he took shelter in this country. So few notes are being heard that if the people from Palestine are not taken by their fellow brothers, let it be taken by India, because we have already taken Bangladeshi, Rohingyas, and long back when Islam came in Iran, it was called Persia, and the people were known as Parsis. They came to India. They never went to any other country, because we believe in Vasudev Kutumbakam, which was the logo of our G20, which you have now remember by heart. But we don't only say this thing, we really implement it in our life. So when the education was started in the Gurukuls, the Guru used to say, Sahana Bhavtu Sahano Bhunaktu Sahaviryam Karvavahi Tejasvina Vadi Tamastu. आपने लिखा है इस पे अपने लोगों में Ma Vidvisha Vahi. So education is a learning, is a process. It's not a degree. We may get the degree, but whole life. I always say I am student of family law. Because there's so many things, new emerging areas which crop up, and we have to learn. And law cannot be static. If it is static, then it will decay. Like a water which is accumulated in a particular place, it will decay. Same as the law has to grow. And with the changing scenario, we need one law in this country, because already we have seen so many problems. So some people say that this is the agenda of one party. Do you believe? Because this particular concept was discussed while the making of the constitution. So during the constitutional debate, this was the only area where the debate took for 2 years. So every day, along with other topics, this topic was discussed. And there were few members who says it should be part of the fundamental rights. So originally it was Article 35. But since there was no consensus on this point, so it was made the part of the directive principles. Now it is in the Constitution as Article 44. State shall endeavor. What is there? State shall. It's not me, remember. So it's a mandate. It's a compulsory provision, which is the duty of the state to comply with. We study during the interpretation of statutes, what is the difference between shall and may? So had it been may, we could say, yeah, the government is excused from drafting the uniform, but it is shall. So at that time, three ladies who were the part of the constitutional assemblies, you might be knowing the name also, one from Christian community, Rajkumari Amrit Kaur, one from Parsi community, Meenu Masani, and one from Hindu community, Hansa Mehta. These three have agitated that uniform civil code should be the part of the chapter of the fundamental rights and not directive principle. But few minorities, mostly they were the Muslims, and they raised their voice that no, it's not feasible to have the because there are so many sects, subsects, schools in each branch. Like for Hindus, Hindu code bill came later on. Originally, there were basically 2 schools, Midakshara, Dyabhaga, and 4 sub-schools of Midakshara, Banaras, Dravida, Bombay, and Mithila. So there was so much diversity. But even then, Dr. B.R. Ambedkar was that for the unity and integrity of the nation, we should have one law. Now you see, we have so many common laws during the colonial period. Once the first law commission was constituted after 1857. So in the name of codification, what we have is Anglo-Indian law. It's all common law which is being enforced, whether it's a Hindu law, Hindu Marriage Act, or it's Hindu Succession Act. With a few alteration, Hindu Marriage Act is the copy of Special Marriage Act. So English law was imposed, and I was reading out one very good article of Indira Jaising. You have heard the name of Indira Jaising. She said that all those areas where the ruler needed for their convenience, they passed laws. They passed Transfer of Property Act, they passed Civil Procedure Code, Criminal Procedure Code, Indian Penal Code, and 1, 2 more, some Contract Act also. Indian Evidence Act. It's all common because these are the area where they have to face some difficulties in their business and administration. She has clearly written in that article. Must go through that, and then you can learn something more about that, which I could not see that in that article. So right from Hastings. They said, we are not going to touch the personal matters, because at that time it was considered that these family matters have that religious origin, so we are not going to interfere. And when the crown took the charge from the East India Company, they also say that we will not interfere in the personal matters. But they do. They have interfered. They pass various legislation relating to the personal laws of the family matters. Do you remember? Can anyone of you tell me which are the areas where they have interfered in the family matters? They passed firstly in 1865 Indian Succession Act, which was applicable to Christians, Jews, and other Europeans, and to some extent to the Parsis also. But when the Parsis raised their objection, they passed separate Parsi Succession Act. Parsi Succession Act in the same year. Now, they also passed Christian Marriage and Divorce Act. Indian Divorce Act 1869 and Christian Marriage Act 1872. These are only for the Christians. But Guardian and Wards Act 1890, it was applicable to all the religious community, irrespective of caste, creed, whatever it is. So even today, when Hindu minority and guardianship is silent on certain areas, the provisions of Guardian and Wards Acts are applicable. So this is family matters. Though they proclaimed that we will not interfere in the personal laws. And then they passed Indian Succession Act of 1925. Well, that was the extension of the Indian Succession Act of 1865, and now it was applicable to all the communities. So today, if two Hindus marry under Special Marriage Act, they are not governed by Hindu Succession Act, they are governed by Indian Succession Act. Similarly, in 1872, they passed Special Marriage Act, which was later on amended in 1954. So the purpose was different. Why they have passed these laws? Then they have also passed Widow Remarriage Act. It was pertaining to the family areas. They also passed Sati Prohibition Act. They passed Child Marriage Restraint Act. And for Muslims, they passed firstly Shariat Act, and then Dissolution of Muslim Marriage Act. Before passing of Shariat law, Shariat Act, all converted Hindus, whether they were Khojas, Kuchi Memons, Moplas, they were still governed by their customary law or Hindu law with respect to their marriage, divorce, succession areas. But with the passing of this Christian Shariat Act, it's clearly said that whosoever professes Islam will be governed by the Shariat law. But the act also says that in certain areas, like if gift and waqf and will. If Muslims wants to be governed by Sharia, they will have to give a declaration. Till today, not a single person has given the declaration that we will be governed by the Sharia law and not by the Indian Succession Act. And it's going on. Now you see, after this passing of our constitution, well, we are to talk about the constitution, what it says. So Article 45 is a mandate which is binding on the government. And this matter has been continuously raised in the Supreme Court as well as in the High Courts. And we know that our judiciary is very active. So that's why the phenomena of proactivism for our judiciary has been conceptualized. Now, Constitution says, firstly, under Article 14, there will be no discrimination on the basis of caste, creed, sex, religion. But all these personal laws have the discriminatory provisions. Mind this. That means we are violating our constitution, which is the grand norm of the country. When for the first time in Mathura, his case, the matter came before the court, they said personal laws are not the laws as conceptualized in the constitution. So they have absolved the personal laws from the purview of the law itself. That means discrimination will continue and no court can declare it as ultra vires of the constitution. If you go in more detail, we find that this discrimination on the basis of religion, firstly, on the basis of religion. For Hindus, Christians, Parsi and Jews, there is monogamy. And if they go for the second marriage, they are held for bigamy under IPC 494. But that is not for a Muslim man. So he can have 4 wives in nikah form at a time. And if want to marry a 5th one, then he can divorce anyone. Now all these persons belonging to these religions, Parsi, Jew, if they want divorce, they will have to go to the court. But a Muslim man can pronounce the divorce out of the court. So there is clear discrimination on the basis of religion. This is one aspect. Now on the basis of sex, a Muslim man can pronounce divorce out of the court and the lady have to go to the court under the dissolution of Muslim marriage. Do you know the history of why this act came? Whenever you study the law, you must see that what was the purpose behind this law, why it came. Iske bina guzara nahi tha kya? Now, when the Shariat law was imposed in 1937, Shariat says if any spouse converts to another religion, his or her marriage will automatically be dissolved. Now, when the Muslim wives started converted, whether they were earlier Christians and they converted to Islam, or they were Hindus and converted to Islam, they started reconverting. So this was a very, you can say, for the fundamentalist, it was a blow. So they requested to the colonial rulers who believed in their policy of divide and rule to pass the law and give certain rights to the women. So they passed the Dissolution of Muslim Marriage Act. They defined certain grounds under which the lady can ask divorce through the court. Earlier, she could ask divorce from in the presence of Qazi. That right was taken. So what she was already enjoying was taken, but nobody objected because the ruler was very strong. You see, now under the present situation, if a Muslim husband converts, his marriage with the Muslim wife will automatically dissolve. But if a Muslim wife converts, her marriage will not dissolve automatically. Is this not a discrimination? It's a clear violation of right to equality. Then coming to other areas, take the example of succession laws. So we have amended Hindu law many times, and now the situation is that both boy and girl, brother and sister, they have equal rights in the property, whether it's the personal property of the parents or it is ancestral property. But that is not so under the Christian law and even in Muslim law. There is discrimination on the basis of sex. The rights of a son is more than the daughter, rights of the brother is more than the sister, and so on, other females of that family. Coming to the adoption law, except Hindu law, no other law has a provision to adopt the child. So if they want a child, what they can do? They can only take a person as a ward and they will be the guardian. So that means they have all the duties towards that ward, but no right against that child whom they have nurtured, they have made, make him study whatever thing he has in his mind. On the other hand, if you adopt a child, it becomes your just like natural born child and has all rights as well as duties towards the parents. Now you see in Goa, all the communities practice this uniform laws. They're Parsi, Jew, Muslims, all have a right to adoption. But except Goa, in no part of the country there is uniformity for the adoption laws. That means if the spouses don't have a right to adopt, what option they have? They'll have to divorce and get for the other marriage. That is the only solution. So again, it is a religion-based discrimination. In guardianship also, under the ancient Hindu law, mother used to be the first guardian, Matri Devo Bhava. Then came the Pitra. But with the Hindu Adoption and Maintenance Act and the Hindu Guardianship and Minority Act, mother's position is secondary. Same in the Christian law as well as in Parsis and Jews. And so far as Muslim law, to my understanding, is concerned, mother has only right to custody of the child and no right of guardianship. She cannot give the child in marriage. So if there's no father, then all relatives from the paternal side will come forward to give the child in marriage. And for the property also, she has no say at all. Mother who has given birth to the child, who has nourished that child for 9 months in her home, has no say about that child's future. So I used to say that uniform civil code is more required for the equality and to remove the discrimination. If you want to give the say to our constitution, we need one law for all. Now, what have been the role of our governments till date? No step has been taken. Once or twice they have referred the matter to the law commission and they says this time has not come. And same was the version some of the member in the constitutional debates, that it's not the right time. So when the people themselves will ask for uniform civil code, then we'll pass the uniform civil code. Now after 76 years of independence, when we will demand, when the people of India who has given this constitution, we the people of India, when we will awake and give the meaning to the constitution, otherwise our provisions of right to equality, right to life has no meaning at all. And I told you that our Supreme Court has been very active, and from time to time they have discussed this matter. Now they say this is not only required to remove the discrimination and give meaning to the right to equality, but also for the unity and integration of the country. Justice MC Chagla has mentioned, who has been a noted judge and ex-minister too, that Article 44 is mandatory provision binding the government and it's incumbent upon it to give effect to its provision. Justice V.N. Khare has also remarked in this discussion, a common civil code will help the cause of the national integration by removing the contradictions based on ideologies. Now, some of the people, they raise the opinion that India is a secular country, so we can't interfere in the personal matters. What does secular mean? What is the meaning of secular? From where this word has come? Because in West, church used to interfere into the personal life of the people. That's why they have coined this word. The church will not interfere in the personal matters. And secular means that government is not favoring any religious community. And you know that in India is the only country where majority have lesser right in the constitution as compared to the minorities. Go and read the constitution once again. Since I was the part of Constitutional Review Committee, and we have given the recommendations, which are the areas where our constitution still require amendment. There have been so many amendments till date. And you know, the word secularism was added with the 42nd Amendment. It was not in the original constitution. If you have the copy of the original constitution in your library, just go and see what is in that constitution. It's like a Bible for a law student. It's a Quran for the law student. It's a Gita for the law student. You must go through the original copy of the Constitution, and you will find many more things. When it is said that secularism will be violated by passing Uniform Civil Code, we know that it was added in 42nd Amendment, and if at that time we could add, and secularism is the hindrance, by passing another amendment, we can amend the preamble. If it could have been amended earlier, it could have been now also amended to give meaning to the Constitution. In Keshwanand Bharati's case, we know what is the basic structure of the Constitution. The basic structure lies in the chapter of fundamental rights also. And the most important is equality. And if these personal laws still continue, this right to equality has no meaning at all. Now in Shah Banu's case, Justice Chandrachud has clearly remarked that Article 44 has remained a dead letter. This is the verdict of the Supreme Court, the apex body. There is no evidence of any official activity for framing a common civil code for the country. A common civil code will help the cause of national integration by removing disparate loyalties. So it is the state which is charged with the duty of securing a uniform civil code to all the citizens. He has also said that a beginning has to be made. We sit and talk on this issue, which are the area where we are common. Long back during my PhD, I have read a book written by Mr. Qureshi, Unification of Marriage and Divorce Laws. He has taken only these two issues, and he has concluded that except few things where we can give the exceptions. Even today, we have given weightage to the customs in the marriage as well as in the adoption. You know it very well. So those exceptions. Now where we can agree that there should be registration of marriage and no community should object it, because registration, if once done, it can give meaning to the Child Marriage Act, it can give meaning to the Dowry Act, it can give meaning to stop NRI frauds too, and many more other benefits. So we have a common code for all, that marriage should be compulsory registered. No one should have objection with that. So if marriage is solemnized, it can be solemnized according to their customs and can be simply written in that. Can we do that? So we have to design firstly all those areas. So long back I have given the suggestion that firstly we should draft it an optional civil code or optional family code. So just like a special marriage act. So whosoever want to marry under Special Marriage Act, they have the option. We had a panel discussion in our own university and we have called the persons from different religious community, and you will be surprised to know that most of the liberals, even in Muslim law, they want uniform civil code. One of the members said that when I will have to marry my daughter, I will not marry her in nikah, I will marry her under Special Marriage Act. Why? The father is afraid that she can be turned out of the home any time. Now we have restricted triple talaq in one go, but we have not curtailed the power of the husband to pronounce talaq out of the court. Most of the Islamic countries have curtailed the husband's power. And even they have stopped polygamy. Our neighboring country, Pakistan, if the husband, Muslim husband, has to go for the second marriage, he'll have to take the consent in writing from the first wife. But in India, there's no such provision. Wife say has no meaning at all. She's just like a chattel. What happened in Shah Banu's case, you know? The husband was an advocate. So in the late 70s, she was turned out of the home. Jao, talaq, 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 aur ghar se bahar. Now when the media approached her, she told, I am not fighting this war for myself, but for my own sisters, who always remained under this threat. Anytime she can be turned out. You know, under the maintenance law too, the right of maintenance under Muslim law is not absolute right of the wife. It's a conditional that she has to obey the lawful commands. And who decides it's lawful or unlawful? It is the husband who decides. So when we say that this is the country who has given the message of universal brotherhood in the form of Vasudhaiva Kutumbakam or in the form of Guru Granth Sahib, where we have incorporated the words of different sages belonging to different castes, creeds, religion. So it's a piece of human brotherhood, human rights. And we have given the message of peace and love to the world during the Ashoka's period. So you go to the China, you go to North Korea, you will find the remains of Buddhist temples. And even today it is said that if anyone can stop this war between Russia and Ukraine, it is India. So everywhere seek for the remedies to the country, but in our own country, we cannot stop this bickering between the different communities just because that one community has more rights and other has less. So that keep on accumulating. जैसे वो प्रेशर कुकर में इकट्ठे होता रहता है ना, फिर वो एक दिन फट भी जाता है या फिर एकदम उसका वो वाल्व उड़ जाता है. सो घर में भी अगर हम एक बच्चे को ज्यादा प्यार करते हैं, उसको पैम्पर करते हैं, दूसरे को नहीं करते हैं, तो उसके मन में तो वो रहता ही है भाई. तो इसलिए मोस्ट ऑफ द जजेस, मोस्ट ऑफ द ज्यूरिस्ट, you can name Asghar Ali engineer, Kamila Tayyab ji, Hamid Dalwai, so many liberal Muslims who have been working right from 50s to eliminate this triple talaq in one go, in one pronouncement. It's not the decision of this BJP government. People have been working for it. And then a government which had some willpower, they had passed it. People have been agitating to remove polygamy in many areas of this country. And now the day has come that if we see uniform civil code from the angle of right to equality, you all will agree with me that in order to remove discrimination on the basis of sex as well on the basis of religion, we need one law for the whole nation. If we are living in this 21st century. We can't implement the laws of 16th century. There have been changes in Egypt, Lebanon, even Palestine with regard to the Muslim laws. Let them go, let them go. Hello, let them go, ma'am. Be comfortable. Let them go. So they might be knowing everything, so they don't want to listen, let them go. It hardly matters. So with this word, there is need to go for research on these areas. Do we really need uniform civil codes? So ball is in your court. So I'll stop here. Thank you for your patient listening. Thanks a lot.
Thank you so much, ma'am, for expressing your expert views on the topic Uniform Civil Code, a constitutional perspective, and enlightening us on the same. It's now time for the question answer round. If anyone present amongst the audience has any doubt or any question regarding today's topic, may please ask ma'am about the same. Anyone?
My question is, according to you, there are various challenges for the implementation of UNCC in India. Could you please say how do we get through this? I know unity and integrity, as you have mentioned, is a part, but then the challenges that would come along maintaining the unity with this actually implemented. Could you please answer this?
Yeah. I told you that different communities before independence and even after independence, they have no objection for single laws in the countries. There are very few who are against it. But the thing is, there is a lack of political will. During the British period, most of the laws which the people never accepted, they imposed. So they had that will as well as they have the control. Nobody could object it. So looking at the various other countries, developed, underdeveloped, so it's the only country, and this issue has become bickering for the various communities. That one is having right, other is not having. They coming to the court, and you remember Awag and others versus Union of India, where various NGOs belonging to the Hindu community, Muslim community, and Christian community has challenged their discriminatory provisions in their personal laws. And the court said simply one sentence, that this is not the right forum. But you have to go to the parliament to enact the law. We have no power. But they even not declared those provisions as ultra vires of the constitution, which they would have done it. Because whenever our fundamental rights is being violated, where we go? We go to the court, we go to the Supreme Court or the High Court in form of writs. And court says, no, don't come to us, we have no solution for you. Then where will the human being or the common man will go? And wherever our courts have struck down those provisions, the government has made the law. Whether you are aware or not, Section 10 of the Indian Divorce Act was discriminatory, and Kerala High Court has declared it ultra vires of the Constitution. It violated right to equality, because under that provision, if the wife required the divorce on the ground of adultery of the husband, she could not get it. She will have to prove adultery plus cruelty, adultery plus desertion, or adultery plus some other ground. Whereas if the husband wanted divorce, simply prove the adultery of the wife and he will get the divorce. Now you see that people want, and many jurists have been working on it, that this is the right time that we must come together to give the teeth to our constitutional provisions, mandate. तो पता नहीं कब हम माइंड तैयार कर पाएंगे. तो लिटरेसी रेट तो अब हमारा 80-85% है, फिर भी अभी हम लिटरेट नहीं है कि ये सोचने के लिए कि यूनिफॉर्म सिविल कोड होता क्या है. एक हवा बना के रखा हुआ है हमने, जैसे 370 को हवा बना के रखा हुआ था. मतलब एक ऐसा प्रोविजन जो टेम्परेरी था, और आज भी लोग कहते हैं नहीं 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 वो तो परमानेंट था. मैंने कहा कहाँ लिखा था परमानेंट इज. और जो लेटर ऑफ एक्सेशन हरि सिंह, राजा हरि सिंह ने साइन किया था, सेम लेटर ऑफ एक्सेशन बाकी राजाओं ने, 500 स्टेट्स की राजाओं ने किया था. उसमें कोई डिफरेंस नहीं था. इट वाज अ क्रिएटेड प्रॉब्लम. और यूनिफॉर्म सिविल कोड को भी अगर हम यूनिफॉर्म फैमिली कोड पे कहते हैं, क्योंकि सारे लॉज तो सेम है. अगर हमें नहीं चाहिए तो लेट्स revert back to the original position before independence, है ना. जहाँ हिंदूज भी पॉलीगैमी करते थे. So why one more right to a particular group of people and not to the others? या तो हमने कॉन्स्टिट्यूशन में राइट टू इक्वालिटी ऐड ही ना किया होता. और जो मुस्लिम ज्यूरिस्ट हैं वो कहते हैं राइट टू रिलीजन का, अगर हम कहते हैं कि राइट टू रिलीजन, तो राइट टू प्रोफेस जो है दैट इज समथिंग एल्स. कि मैं मंदिर जाऊं, गुरुद्वारा जाऊं, मस्जिद जाऊं या चर्च में जाऊं, इट्स माय पर्सनल मैटर एंड द गवर्नमेंट विल नॉट इंटरफियर. बट व्हेन इट कम्स टू द सिविल राइट्स, व्हेन इट्स टुवर्ड्स द सोसाइटी, सो मैरिज क्या है, हस्बैंड एंड वाइफ के राइट्स हैं, उसमें रिलीजन कहाँ से आएगा. बिकॉज लॉ, व्हाट इज लॉ? टू रेगुलेट आवर बिहेवियर विद इन द फैमिली एंड आउटसाइड द फैमिली. एंड दोज लॉ विच कैनॉट रेगुलेट आवर बिहेवियर, we don't want such laws. Thank you. Sure. Firstly, it will remove the discrimination on the basis of sex as well as on the basis of religion. So every citizen will enjoy his right to equality. Now you see what is halala. You know what is halala? Means divorce देगा husband और wife को एक कहीं और शादी करवानी पड़ेगी, फिर उसकी दया दृष्टि पे रहना पड़ेगा. वो जब तलाक देगा फिर वो वापस. अब बाकी सभी जो पर्सनल लॉज हैं, हिंदू, क्रिश्चियन, ज्यू, पारसी, डिवोर्स हो गया. इफ दे वांट टू कम टुगेदर दे कैन कम टुगेदर, दे कैन रीमैरी. और जुडिशियल सेपरेशन का प्रोविजन है ही नहीं मुस्लिम लॉ में, तो ये डिस्क्रिमिनेशन नहीं है औरतों के लिए. एंड दे आर साइलेंट बिकॉज उनको बहुत लंबे समय तक घर में ही रखा गया, पढ़ाया नहीं गया. नाउ दे आर वर्किंग फॉर इट. दे आर डिमांडिंग, दे आर ऑल्सो डिमांडिंग फॉर द मॉडल निकाहनामा, where all the things should be in black and white. तो जो ह्यूमन राइट वायलेशंस इन डिस्गाइज हो रही है ना, साइलेंटली हो रही है, और हम भी चुपचाप उसको, जैसे कबूतर आंखें बंद कर लेता है ना कि मुझे बिल्ली नहीं दिख रही तो बिल्ली चले गई, ऐसी स्थिति है इस समय. सो हमें आंखें खोलना पड़ेगा, एक अवेकन्ड सिटीजन की तरह काम करना है। सिटीजन की ड्यूटीज पता है ना, और कॉन्स्टिट्यूशन हमें सिखा रहा है अब तो ड्यूटीज भी। पहले हमने जब इसको ऐड करना था कॉन्स्टिट्यूशनल डिबेट में, सबने कहा क्या जरूरत है ड्यूटीज का चैप्टर ऐड करने की, ऑलरेडी इतने सारे सेक्शन हो गए। क्योंकि हमारा तो जो देश है, इट इज बेस्ड ऑन ड्यूटी इटसेल्फ। धर्म हियर मीन्स ड्यूटी, धारयति इति धर्मा, those principles which we apply actually in life, that is dharma. Worshipping is something else and practicing, I'll give you one example कि धर्म क्या है, then you will understand it more clearly. एक जज का धर्म क्या है? न्याय करना ना, whether he is a Hindu, Muslim, Jew, Christian, वो धर्म तो सेम ही है ना उसका। इसी तरह वो टीचर जो है, उसका वट एवर रिलीजन, जो उसके वे ऑफ वर्शिपिंग है, वट एवर इट इज, उसका धर्म यही है कि वो एजुकेट करे, वो अपने स्टूडेंट्स को अवेयर करे, उसमें जिज्ञासा पैदा करे और जानने की, अच्छा इससे आगे और क्या। जो मैंने आज कह दिया वो फाइनल नहीं है। हमारे किसी भी ऋषि मुनि ने नहीं ये कहा कि जो मैंने कहा वही ब्रह्म वाक्य है। देयर इज अ लॉट ऑफ स्पेस फॉर वाद, संवाद, परिसंवाद, डिस्कशन, डिस्कोर्स एंड, तो हमारा तो ये कल्चर इसी पे बेस्ड है। हम धीरे धीरे भूल गए हैं, हमें थोड़ा वो सुप्त अवस्था से जागना पड़ेगा। ओके, वेलकम सर, वेलकम। थैंक यू।
Then I have a small question of mine. Actually, as you all are aware that we are having a court cases pending, High Court, Supreme Court, and they are not being cited in a time-bound manner. So, can you suggest any order in Indian context so that they can be cited in time and we can get justice timely?
Yes, we had a model of panchayats where we settle down our things at the village level, and the person were selected on basis of their integrity. But during the British period, we dissolved that system. So everyone who wants some justice had to come to the court. Those who could not afford the court fee could not come. And now same is the position, that those who can't afford fee, they cannot go to the High Court or to the Supreme Court. सुप्रीम कोर्ट जो है वो खास लोगों के लिए रात को भी बैठती है, लेकिन बाकी लोगों के लिए बहुत छुट्टियां हैं उनके पास, plenty of holidays they have, plenty of excuses they have. So हमें अपने ये बच्चे जो इनमें से जो जुडिशरी में जाएंगे या पार्लियामेंट या कहीं असेंबली में जाएंगे, इनको सेंसिटाइज करने की जरूरत है, that they should come forward, or alternative dispute resolution, which is the emerging area, they should focus on that, and there's a lot of scope in that. Right, sir?
I think all the questions are done, and we can move forward. I would now like to request Mr. Pramod Kumar Goyal sir to deliver the concluding remarks. Please give a big round of applause for
Thank you, ma'am, for incredibly enlightening session, providing us a deeper understanding of the complexities and implications of the Uniform Civil Code. The insights shared are thought-provoking and have sparked our imagination and curiosity about the critical aspects of our legal framework. Ma'am discussed the subject in deeper details. And while discussing, she shared that the matter was discussed for 2 long years during the constitutional debates. Ma'am, if I am permitted, and I'm not wrong, if I'm not wrong, during the debates, a theory was propounded that the Uniform Family Code, which the ma'am referred, that is the matters relating to marriage, succession, inheritance, etc., should be governed both by the personal laws and uniform code. They must coexist. If somebody wants to be regulated by the uniform code, he or she must give a declaration. And once the declaration is given, he or she would come out of the ambit of the personal laws. But if no such declaration is given, then the personal law shall regulate their lives. The theory of this theory of coexistence of two systems could not get the support of the Constituent Assembly, and therefore they thought it proper to place the subject in the chapter regulating the directive principles of state policy, and therefore, hence this Article 44 came in. This was crafted in the Constitution in the hope that in future, when we are mature enough, we'll adopt. But unfortunately, after so many years of independence, that day has not yet come. Ma'am's deliberation has given us the understanding, made us understand the constitutional framework, national integration, legal equality, secularism, women's rights, pluralism and diversity, analyzing the challenges and opportunities related to public opinion, understanding the need for legal reforms and political challenges, socio-legal implications, and comprehensive understanding of the constitutional aspect and its political implication on Indian society and legal system. Thank you very much, ma'am, for enlightening us. We are obliged to you.
Thank you so much, sir. I would now like to request our Honorable Vice Chancellor, sir, to present the memento to our guest speaker of the day, Professor Dr. Vinny Kapoor Mehra, ma'am. Please, sir. Please give a big round of applause for ma'am. Last but not the least, I would like to request Ms. Arpana Tyagi, ma'am, Assistant Professor, SLCS, to kindly come up on stage for our vote of thanks.
A very good afternoon to one and all present. I, Arpana Tyagi, Assistant Professor from SLCS, on behalf of entire fraternity of SU Meerut, would like to take this opportunity to express my heartfelt thanks and sincere gratitude to Professor Dr. Vinny Kapoor Mehra, ma'am, our guest speaker of the day. Thank you so much, ma'am, for taking out time and presenting your thoughts before us. Your insights and perspective are truly valuable, and we all thoroughly enjoyed your lecture. We all are really grateful for the knowledge you've shared with us, I would also like to thank Honorable VC Sir for his words of wisdom, Mr. Pramod Kumar Goyal, Director SLCS, and all the faculty members and students for making this event a success. I would also like to thank Registrar Sir, Raj Kishore Sir, Avinav Pathak Sir, Prempal Sir, and his team for working tirelessly to ensure that everything falls into place. And last but not the least, I'd like to thank my very dear friend and colleague Shubham Sharma for helping me yesterday because I wasn't well. What would I have done without you? Thank you. Thank you so much.
Thank you so much, ma'am. Indeed, today's session was filled with a lot of knowledge and learning. Therefore, I would like to sum up this event by thanking our chief guest of the day, Professor Dr. Vinny Kapoor Mehra, ma'am, for gracing the event with her presence and sharing her valuable thoughts with us. I would also like to thank Vice Chancellor Sir, all the Dean Directors, faculty members, and my fellow mates for being present and making this event a successful one. Thank you, everyone, and have a good day.
BCA first year, all the students will please remain seated. आप लोग की